The two challenges are tied with the former being the key to unlocking the latter. The executive and the legislature plays a key role in allocation of resources. It is important for the parliament to ensure it passes sufficient allocation in the budget to ensure services of judiciary are not compromised. The process of appointment of judges remains well regulated by the Constitution of Kenya and the Judicial Service Act 2011. The Judicial Service Commission declares vacancies, advertises, shortlists, interviews, and recommends the successful candidates for appointment to the President. Among the members of the Judicial Service Commission is the Honorable Attorney General, Chair of the Public Service Commission, and two members appointed by the President to represent the interests of the members of public. The foregoing four members should be in a position to communicate any concerns that the executive and the members of public may be having on candidates during the interview process. For the Attorney General to come later to say that there are integrity issues on some of the 41 candidates is a confirmation that together with the three commissioners, they failed in their duties. To sustain this argument, the honorable thing for them to do is to exit the Judicial Service Commission. Further, the Honorable Attorney General to come out to pour cold water on a process he was part of is appalling. It only points us to the path of impunity, which gives one the courage to run away from the decision that he was part of. One of the cardinal principles in justice system is that for the right to be heard before being condemned. In the failure to appoint the recommended judges, we are facing a situation where we are told some have integrity issues. This has cast aspersions on the character of all the 41. Such casual way of leveling allegations is not justifiable in a society where the rule of law is respected. We state that the expression of the Chief Justice on the pending appointment of judges and respect of court orders is expression of frustration we advocates have experienced and continue to experience. The Honorable the Chief Justice, as the head of the third arm of the government, is primarily accountable to Kenyans. When all other avenues of communication are closed, it is within his rights to inform the members of the public. We humbly urge His Excellency, and I repeat, we humbly urge His Excellency, the President of the Republic of Kenya, to proceed to appoint the judges. It is in the interest of the members of public and affirmation of the respect of the rule of law for him to do so. Following the directive of the Chief Justice, the Court Users Committee in various courts within our branch have met and made resolutions on how courts should operate in the advent of COVID-19 pandemic. This will lead to resuming of open court hearings gradually as from Monday, the 15th June this year. We would like to urge both advocates and litigants to continue observing the protocols set by the Ministry of Health as they access court premises. You need to wear face masks, wash your hands, have your temperature taken, and keep social distance. We would like to bring to the attention of the members of public that we have agreed that only the litigants whose matters would be going on in courts are going to be allowed into court premises. The courts shall put in place mechanisms of controlling who is coming into court premises to avoid overcrowding. Lastly, as we confront the COVID-19 pandemic, let us have in our minds that nothing should be allowed to compromise the rule of law. May God bless you. May God bless Kenya. Thank you. Justice Mutia, Chairman for LSK Southeastern Branch. I would like to issue this statement on the condition that we are in, on the issue of the appointment of the new judges, and also on the upscaling of our courts in the region. As one of the branches of the Law Society of Kenya, established under Section 24 of the LSK Act, we come out to hand our voice to the ongoing debate on pending appointment of 41 judges to the superior courts. We are cognizant of the fact that on 8th this year, the Honorable the Chief Justice issued this statement raising the issue on the delay of the appointment of the 41 judges. He also raised the issue concerning the obeying of the court orders that are variously issued by various courts, and they have gone without being obeyed. I will not belabor the point anymore, but I would wish to state that the challenges that face the judiciary in this country are well documented in various reports, and more specifically in the various status reports on the judiciary. Key among the challenges is limited allocation of resources and acute staff shortage, which has led to excessive workload. I want to challenge the commissioners that represent the members of the public in the commission, and also the Honorable Attorney General, as well as the chair for the Public Service Commission, if they really feel that the process that they participated of recommending appointment of the 41 judges was not above board, then the best thing for them is to resign. They should not be attacking a process which they were part and parcel of. On the part of the Honorable the Attorney General, he is part of the Judicial Service Commission by the virtue of his office. As a representative also for the President, he has an access to any information that would come to the government on the issues or touching on the candidates that were interviewed. Our expectation is that during the interview process, he should have been in a position to bring out any issues of integrity that were touching on the so-called, that were touching on the candidates that came for the interview. Also, the 3 appointees of the President that sit in the Judicial Service Commission provide an avenue also for the President to communicate to them any issues that he would like to be addressed during those interviews. And because this is the process that is under the Judicial Service Commission, we believe the Constitution has created the necessary safeguards by having these 4 commissioners sitting there and raising whatever issues they have. On the issue of the impact of non-appointment of the judges, we realize that there is a problem of backlog in our courts. Today, those who are going to file matters or to seek hearing dates at the Environment and Land Court at Nairobi, their possibility of being heard any soon is in the year 2022. We are facing the same problem in the Employment and Labor Relations Court. For your information, this region, that is Kitui, Mwingi, Kajiado, and Machakos, is served by Employment and Labor Relations Court judges at Nairobi. We are also facing a problem for matters in that court moving because of the shortage of judges. Ideally, we should be having Employment and Labor Relations Court judge in every court, or rather in every county. And we are facing that serious problem in the country. As a gentleman, early this year, the Honorable the Chief Justice and to recall all the judges of the Court of Appeal that were sitting in stations outside Nairobi. The decision was informed again by the shortage of judges because the courts are not operating in the optimum. Any person going to our courts will tell you that as we are speaking today, the Court of Appeal, the Environment and Land Court, the Employment and Labor Relations Court are 3 courts now that are not operating in the optimum.